What's up, everyone? Welcome to Let's Talk Markets with Dave Lauer. I'm your co-host, Pink, and today we're going to discuss a couple of recent SCOTUS rulings, the Jarkesy case, Relentless, and Loper, and how that may affect regulatory agencies and their ability to enforce, among other implications. So a quick disclaimer before we jump into the conversation, this will be a more politically focused than our other conversations. We do stand firmly at Urvin in the purple between the red and the blue because our underlying mission statement is above political affiliations. But this conversation is obviously inherently political, and there will be mentions of party affiliations, politicians, and other direct party topics. Please be advised that we will be stating the facts as they are understood by experts, as well as sharing individual opinions. So with that out of the way, we're very excited to jump into this conversation, and we've brought back our friends from previous episodes. We have professor at the William S. Boyd School of Law at UNLV, Ben Edwards. And then we have the assistant professor at Chicago Kent College of Law, James Tierney. So thank you guys so much for joining us again today. It's good to have you back.
Yeah, thanks, guys.
Thank you. Glad to be here.
Really happy to be back.
So let's jump right into it. This is a really meaty topic, and we don't want to waste any time. I want to start with a quick summary of the two cases, if you don't mind. So, James, can you give us just a quick summary of the Jarkesy case? And we can also link to the previous episode in which we went deep into it for anyone that missed that. We'll put that up in the corner here. But James, do you mind just giving us a quick summary?
Yeah, so the kinds of policymaking that we're going to be talking about today involve two different ways of making policy. One is rulemaking or prospective policymaking that's generally applicable, or adjudication, or the application of existing or evolving rules to particular parties. Ben will talk a little bit in a moment about rulemaking, but as to adjudication, the court in Jarkesy held that it's unconstitutional to assign certain kinds of cases to an agency adjudicator. And here they held that civil penalty actions for securities anti-fraud were too much like common law fraud actions that you always would have had to bring in court until the Dodd-Frank Act. So there are some other kind of consequences of the Jarkesy case, but that's the big picture.
Excellent. Thank you. And Ben, if you don't mind, we're also going to be talking about the Chevron deference. Why is it important? What does the Supreme Court's decisions in Relentless and Loper Bright mean for regulatory agencies?
Okay, so probably the easiest place to start is what is Chevron deference? What are we talking about? So Chevron is this Supreme Court case that has been around was around for my entire career as a lawyer, and essentially what we're looking at is a rule that is an interpretive rule for courts. Like when an administrative agency, say the SEC or some other administrative agency, makes a rule, it's got to interpret a statute and make a rule. And then the court is ultimately going to take a look at it and review it and to see whether or not the agency's interpretation of that rule should stand. Now, Chevron has a couple of steps to it, but essentially what Chevron would say is if the language of the statute is somewhat ambiguous and the agency has constructed a rule that is permissible, it's a permissible reading of the statute to construct it that way, even if the court doesn't think it's the best way to read the statute, it's going to defer to the administrative agency, on the theory that the administrative agency has a lot more substantive expertise, they know what's going on, and Congress gave the right to interpret the statute in the first instance to the agency. Now, Loper Bright, Relentless or Raimundo, what we're looking at here is the Supreme Court overrules that Chevron doctrine and essentially says, no, it's the court's job to interpret statutes. And so if there's an ambiguous, statute and there are multiple possible interpretations of it, it's the court's job to decide which one is the right one. And so if you have an administrative agency like the SEC making a rule, and there's some ambiguity around it, ultimately it creates a lot more uncertainty. What will happen if that rule gets reviewed?
Okay, that's thank you. That makes sense, and I, to me, Chevron is maybe the more interesting topic here. But I want to start with Jarkesy, and I mentioned to both of you, I was reading an interview with the Jarkesy lawyers. And I think their points were interesting, and I'd be really interested to hear your reactions to them. The first one was about the bias in these administrative law proceedings, that nobody was winning these cases at all, right? It was almost, they said they looked back a couple of years, they couldn't find, a case in which somebody won against the SEC. I don't know how accurate that is. So, James, I'd be interested to hear how accurate that is. I know you were part of this process at the SEC, but they said they were shocked by the quote, the lack of due process, the lack of any effective discovery, the lack of rules of evidence, which did not apply except when they did, and that the whole process was very biased toward the SEC. According to them, the whole purpose of administrative proceedings is to have expert summary, efficient, and timely adjudications. But for this case, the SEC actually sat on the appeal for 6 years. And at that point, the courts had changed dramatically. And so it was very timely, I think, from the perspective of those that want the Jarkesy outcome that they got, because you were dealing with a completely different complexion of activist courts. You went from sort of left-wing activist courts now to right-wing activist courts. So, James, how do you react to that quote, first of all?
Well, let me begin by saying it feels a little bit like a personal attack, not from you, but I say that. No, I say it because as full disclosure, I worked at the SEC Office of the General Counsel office that handled appeals from the administrative law judges to the commission. And, I was there from 2015 to 2020, which I think is, part of the overlap in window.
There's
and
overlap,
this was before Jarkesy was here. I was aware of this case, but I was not involved with it. I think what I'll say is there are two components of the criticism: bias and like a win rate issue. As to bias, well, actually, let me start that to say that there are actually three things, right? There's bias, win rate, and a difference in what the forum actually looks like. And I don't want to minimize that last point because it's actually maybe the most important. And Justice Gorsuch has a concurrence in his case that talks a little bit, that focuses on this. But the idea is that, there's something really different about administrative adjudications where, it's not before a jury, it's not before an Article 3, life tenure protected judge. There are these differences in evidentiary rules and things like that. Those are real meaningful differences, and they do have consequences for things like, what sorts of evidence can be introduced against you that might not be introducible in court, right? Because the rules of hearsay are different, for instance. To be on the wrong side or the receiving end is to perceive being on the wrong side of administrative justice. And so, I don't want to minimize what the kind of human toll of this, the SEC's choice to bring cases in one venue or another, right? The problem is that I don't think it necessarily means anything for bias or anything necessarily for win rate. As to bias, I certainly never saw anything from an insider's perspective that looked like bias. It's certainly the case that, the SEC is full of kind of mission-driven public servants who, believe in investor protection and believe that like someone who has violated the anti-fraud laws, and like it's pretty clear that what this guy did was like lie to all of his investors about, what his kind of prime broker was, and, doing all sorts of things that as an investor, I would certainly want to have other people deterred to do, right? And so I think there are a lot of folks in the building who think, if you violate the securities laws, you should probably there should be some consequence for that, right? And that's very different from bias. Right. But the last thing I think related to win rate, is that there are different cases that can be brought in court versus in before the agency forum. There are different sanctions that can be gotten in each forum, and so it's not always it has not always been the case that just because you get more kind of SEC victories, that there's something wrong with the process. It could be, and in fact, after a previous Supreme Court case, it definitely was the case, after 2017, that the SEC just, so let me spell that out a bit more. After this case called Lucia in 2017 that faulted the way that the SEC had appointed its administrative law judges initially, as not consistent with the Constitution, the SEC basically shifted the mix of cases that it started bringing in its administrative forum, and they started looking like, cases to deregister a public company that had gone delinquent in its filings for several years, right? And like the company is probably bankrupt, or it's like, it's defunct, it's defaulted, right? And so, you have to go to court now to bring all of those cases. Also, right now, I think most of the cases before the administrative forum involve follow-ons where, an investment advisor gets convicted or, enjoined of fraud. And one consequence of that, pretty summarily as a matter of securities law, is that you might get kicked out of the industry, barred permanently as a consequence. And so that's kind of what the mix of those cases generally looks like today. And so, cases where people don't show up, cases where, and they've defaulted, right? You would expect a really high win rate. And so I don't know that you can put a whole lot of stock into some of those indicia of kind of unfairness, but there is something to the point that the Jarkesy lawyers had to say about about the problems with the process. I am not entirely sure that anyone has been driving the boat here, though, in the sense that lawyers are very good at picking up arguments that will be good for their clients. This argument was great for Mr. Jarkesy and great for his Patriot hedge fund, right? But is this part of an ideological project to dismantle the administrative state? I think there are some participants in this broader trend for whom that is the goal, but that doesn't necessarily help us answer the question of where the stopping point is going to be. And we'll probably talk about this more later today, but some of the implications of this case where the premises might sound framed the right way as this is a really unfair forum. The consequences might be really, really catastrophic, in some sense, either for administrative justice or for the kind of plumbing of the capital markets. So, on that point, right, Ben, I think, sent around a case that had been, an extension of this Jarkesy.
It was filed a week ago.
Yeah.
Yeah. So
yeah, and I think a lot of our listeners, they often express this view that they want to see more enforcement actions, and they want to see enforcement actions with graver consequences. That people should be kicked out of the industry for wrongdoing, and that there needs to be much more stringent repercussions, extreme repercussions for securities fraud. And so I'm curious, given this case that was filed, Ben,
so I have a view on that.
You give a quick overview of what it is, and what are the implications for people that believe that?
So one way to think about how should the SEC respond to these kinds of decisions? And so the SEC's goal, as I understand it, is to deter fraud and misconduct. And there's a couple of ways to do this. One way is to slap a lot of wrists, and the other way is to chop off a few hands. And so, when you think about it that way, if they're going to have to go to court, they're going to bring some pain with them. So the SEC is seeking penalties in these kinds of cases. Usually right now, it's trying to seek a penalty that's appropriate in the interest of justice. Will send a message to the industry and try to change behavior. And so if you have some pretty standard kind of routine violation, and you can deter it across the industry, through routine enforcement in administrative courts, great, you'll get that done. If you want to achieve the same enforcement, and deterrence benefit with a smaller number of cases, you might have to scale up the kind of penalty you're seeking. And so this, in some sense, this could be a little bit unjust in terms of just distributional justice, because you have, say 10 different people in the industry who've done functionally the same thing. One of them gets hit with a hammer, and the other ones quietly change their practices, versus, a different system where a lot of this runs through the administrative court, where all 10 of them get their wrists slapped, and behavior changes. So that's one challenge here. Another challenge in the aftermath of this is, well, if the SEC is going to mount up and go out and bring these cases in federal court, it's going to need more resources and it's going to need more money, because lawyers aren't cheap. And the kinds of lawyers who can bring and litigate cases effectively in federal court are also not cheap. And once they have a history of doing this, it's very easy to poach them, to go somewhere else. So the SEC already pays at a heightened pay scale over most other federal administrative agencies. But they're really just going to need a lot more resources if they want to keep enough lawyers in-house and able to do this and scale up in a way that makes sense. So it's the enforcement side, I think, is going to be a real challenge.
I think you hear a lot from Gensler every time he's testifying before Congress that he doesn't have the resources he needs, even today. And so I think that's what you've just said is pretty concerning, because if now the SEC needs far more resources to actually enforce its rules, and as we're going to talk about later, we're potentially heading into the next presidential administration. Who knows what's going to happen in this election? But it's clearly possible that you end up with an administration that does not prioritize the funding of regulatory agencies, and so from that perspective, this could all get much worse if you believe that regulatory agencies, and especially the SEC, aren't doing enough to enforce their rules and aren't bringing enough cases as it is today.
Yeah. So one way to think about this is, as our capital markets have grown in size and scope, has the SEC grown at a similar pace? And I think no. And some of that is probably fine, because the SEC is the benefit of more modern technology. It can rely a lot on SROs, which have grown substantially. But it certainly hasn't scaled up in the same way as our markets have. So as our markets have grown to be the largest and most robust in the world, the SEC, it has grown, but it needs to grow a lot more in order to keep pace. Because if markets are growing pretty dramatically, and the SEC is growing more slowly, your overall level of enforcement is just diminishing.
Yeah, and it's funny. It's like it's not just. I would make the argument from that perspective. It's not just a matter of sort of notional growth, but the explosion of sophistication and complexity, right? And you have markets that have become, for the most part, all electronic. Certainly in the equities markets, that's the trend in many other markets as well, and you have the wealth that's being created from the mastery of the complexity of these electronic systems growing pretty significantly, and therefore the incentive and the resources behind either manipulation or whatever any securities law violation, all of these incentives are shifting in the wrong direction. And you have an agency which is mostly lawyers, no offense to any lawyers, but not dominated by data scientists and industry experts. And I think that to me is probably the more fundamental issue, where I don't know that you even necessarily, I think that the SEC needs more gross resources, but from a fine perspective, it really needs different resources, and those resources are really hard to secure without appropriate funding.
Yeah.
So
I know some people who work there in those kinds of roles, but you are undoubtedly right. There's a quick Madoff story here. When the SEC was going to interview Bernie Madoff, the attorney who was set to interview him before the Ponzi scheme came to light did not understand options, and had talked to some people internally about what's a put, what's a call, and was told, you need to study up. I don't think you understand this well enough. She went ahead, did the interview, didn't find anything wrong, surprisingly, and the Madoff Ponzi scheme kept going. And so that deficiency has been well known, and the SEC has been working on it, but I think it still needs just many more resources.
So just to jump in, I would certainly agree that the SEC needs more resources, but I also want to take maybe the zoom out perspective and throw some cold water on this, which is to say the SEC is perhaps one of the best, has some of the best capacity for administrative, policy making around areas of like both complexity and importance for the national economy. By one measure of one of our colleagues at the University of Minnesota, Nick Bednar, looking at like administrative capacity, found the SEC to be like far and away like the one that had the most. So it does suggest that if this is not going to be limited to the SEC, and if the consequences of these cases are going to ripple across all the other agencies and all the other kind of industrial sectors of the regulated economy, then that the situation will be more dire for them. The other thing I wanted to just circle back to is this idea that what we're trying to do is promote enforcement, and that making it harder and longer to do that is going to like be bad for market integrity or stuff like that. I would say that the making the cost of enforcement go up is closely related to whether or not we're being effective at deterrence of the stuff that we don't want. But the trouble with this is that in the Jarkesy case, the Chief Justice Roberts, opinion talked at some length about how what's different about this kind of anti-fraud case as compared to OSHA regulations or whatever else is that this is meant to deter. And so the incentive for lawyers is going to be to chip away and to say, well, look, Jarkesy really says that anything that deters has to go to court. And so that's going to continue this feedback loop of increasing the cost of enforcement and reducing the kind of amount that we're able to effectuate like deterrence through policymaking other than through, very costly litigation in court. And even in a world where most cases settle, the idea that if you rest on your laurels, you might be able to go to court and get like a sympathetic, decision maker to agree with you, means that you're going to be able to get like a much smaller slap on the wrist in settlement than you would in the counterfactual world.
So a lot of implications from Jarkesy on enforcement and deterrence and what this might mean going forward. I think it's interesting. We've only really focused this conversation on the SEC, but the point being, this is a case that's going to affect lots of different regulatory agencies. And the second set of cases we wanted to talk about will have even broader impacts across the regulatory and administrative state. So, let's switch gears over to the second set of cases, Relentless Inc. versus the Department of Commerce and Loper Bright Enterprises versus Raimondo. I wanted to start off with just like a quick bit of history that I think is really relevant to this conversation. And we're going to be talking about the Chevron decision and a doctrine called Chevron deterrence. And, where that came from was the Supreme Court upholding a Reagan-era Environmental Protection Agency interpretation of the Clean Air Act, which eased regulation of emissions. And conservatives at the time were pretty thrilled with that decision. They applauded Chevron, and now we find sort of this pendulum swinging the other way, where conservatives are now excited that Chevron's been overturned because they see regulatory agencies as guilty of overreaching their statutory authority. So as we talked about in the introduction, the Chevron deference is this idea that when Congress passes a law that has some level of ambiguity or deference to a regulatory agency, the regulatory agency is best positioned to interpret that and figure out exactly what it means for the rules and regulations it's creating. And now the court is saying, no, that's not true. The courts are best positioned to make that interpretation. And so, I think it's funny that you had conservatives applauding the first decision. Now they're applauding this. Let's consider a hypothetical scenario in which we do have a change of administration coming in the near future, or any future conservative administration, wouldn't this open the door for liberals to challenge regulatory agencies in the same way that conservatives feel like they're going to be able to challenge things today?
Oh, absolutely. So one way to think about it is, if you go back to the Chevron decision, if you have a decision loosening, some sort of regulation in an ambiguous way, where it's perhaps not the best interpretation of the statute, but it's certainly permissible, you would challenge it under this new decision, and you'd try to find a sympathetic court that would say, no, you can't loosen this regulation. Right. You have to maintain this higher standard of regulation. It would throw that ultimate decision, to the courts.
Yeah, I think that what we have been seeing very much in recent times is courts maybe even reflecting the polarization of the country, right? The courts are becoming more extreme on both sides and more activist. Really, fundamentally now, courts are inserting themselves in ways this adjudication process is inserting itself in ways that I don't think we have seen, at least in recent times. I'm not enough of a student of judicial history to know if this is similar to the past or not.
So activist is one of these words that I struggle with myself. Often activist is usually just a court decision you don't like, and so if so they're getting more activists as they're doing more stuff I don't like. I think that's fair. The hard thing is if you look at Robert's opinion in Loper, his view is that the Administrative Procedures Act or the APA essentially says that courts are supposed to be interpreting the statute, and he thinks that he is being faithful, and that Chevron was an activist decision. And so I have some degree of sympathy for the reasoning, but at the same time you can't look away from the consequences overruling Chevron's going to unleash and moving away from that precedent.
I would add to Ben's point that it's not just that these cases moving forward are going to redirect more of these challenges to the judiciary moving forward and really bolster the role of judges in policymaking and everything like that, making them like a central veto gate over administrative policymaking kind of moving forward. It doesn't necessarily mean, though, that, if there's a Trump administration and liberal, groups come in to challenge with litigation, that sympathetic court Ben mentioned is likely to actually give them a sympathetic ear. Because the other part of all of this is that we have learned that courts are not just, as Chief Justice Roberts said in his 2005 or whatever confirmation hearings, they're not just calling balls and strikes, they're deciding the location of the strike box and moving it for case to case and changing the rules of baseball. And so, from that perspective, I have very little confidence that, the sort of the hope, and I don't mean to put it in your words this way, but the hope that that libs will be able to use these cases as swords against conservative policymaking, to me, that is it misreads how courts work these days, and courts have now become the battleground, right? So the idea is that it raises the stakes of someone else, of liberals not just bringing challenges, but themselves contesting who is on the courts, right? Because ultimately, the identity of the justices in great degree dictates their jurisprudential commitments and the vision they see for the future of the country.
Yeah, I think this is very much like a legal realist view.
I think the way that I see it is not anything in the near term. I think you're absolutely right. To me, this is more of a couple decades from now, are conservatives going to be looking back because the courts have swung? Like, it's clear the courts are very activist on the, from a right-wing perspective at this point. And that's how it's going to be for a while due to the nature of our political system. But it will swing back, right? If there's anything we know about history, I mean, I'm a big proponent of the pendulum, Schlesinger's pendulum theory. It's going to swing back. There's just no way around it.
It gives you some hope.
Yeah, I mean, I kind of get, there's a bit of amusement, and that's not to diminish sort of the near-term consequences of some of these decisions, but again, like it seems to me that we'll be looking back and we'll be saying, we thought these things were going to mean X, and they did 5-10 years out, but then as things swing, they're going to mean something very different. But really, to your point, like Gorsuch's quote really just cracked me up, and it's not often that I say that about a brief that comes out of the Supreme Court. But he said, all today's decision means is that going forward, federal courts will do exactly as this court has since 2016, exactly as it did before the mid-1980s, exactly as it's done since the founding, resolve cases and controversies without any systematic or systemic bias. And then he said, in the government's favor. I mean, like, what can you even say to that, right? Like, these courts are so clearly systemically biased in one way, right? And it's fine. They're not biased towards the government. They're biased in a completely different direction. But what I think we have seen is that the implications of a lot of these decisions tend to be that there's bias in the favor of corporations rather than in the favor of government. To me, that's sort of the fundamental difference. And so, like, people are now going to get this corporate state that that the right wing tends to be driving towards. And it's almost like these arguments against, and there will be implications across the federal ecosystem, healthcare being a big one of them. And, I always hear this like, oh, nobody wants the government involved in healthcare decisions, which, I generally agree with, but you want like these crazy private companies that do terrible things to people to actually be the ones there. And I think we're going to see like that as a microcosm is what we're going to see across now the federal government.
I think there's a tension between, on one hand, the kind of pro-business, commitments of like the conservative coalition and like the judicial aggrandizement like trend that we see with these Supreme Court cases, where I totally agree with you that like, pro-business is up in the pantheon of things that the Supreme Court is trying to do. But the number one thing they're trying to do is improve their own and maximize their own power and like their own role in deciding things. And so I challenge a little bit, and this relates to the issue about like self-regulatory organizations being on the chopping block. There is this tension between a vision of like a market-oriented corporatist society, one that promotes self-regulation, things like that, is a very decentralized and distributed vision of authority, expertise, decision-making power. And this is very much about, Chevron deference. It's all about, we are the deciders. The rest of you can tell us what tell us your opinions, but we decide, right?
Yeah. There's a part of this that's, what does the dog do when it catches the car? So Chevron, it created this uniformity where, if say the Fourth Circuit, saw something one way and the Fifth Circuit saw it another and the Sixth Circuit saw it another, if they all agreed that it was, that it was roughly ambiguous, they would just, each circuit would stand down and, defer to the administrative agency's interpretation. Now, you're going to have a lot more circuit splits where, courts are supposed to go with what, the best interpretation or what they think, the law is. And if the Fourth Circuit sees it one way and the Sixth Circuit sees it another, suddenly you've got a lot more circuit splits. And that's going to be the reality in the aftermath of this, because if every time you're challenging, regulations and you're having, different, courts come out with what they think is the different, best interpretation, how do you resolve it? It's ultimately going to have to all, go to the Supreme Court. And the Supreme Court doesn't take that many cases. And so when you think about, this case in Corner Post, they didn't just say, in their recent series of cases that new rules can be challenged under this. Old rules can also be challenged under this if a new business entrant is suddenly affected by it. And so basically everything is up for grabs at this point. So you're going to have, you may even have, it wouldn't surprise me, this would be a fun thing to put an RA on. It would not surprise me if you have lines of cases out there where different circuits have said, we each think these different interpretations are the best interpretation, but we're going to defer under Chevron. And so you may have pre-existing judicially recognized differing interpretations among circuits that were sort of suppressed and glossed over because of Chevron. But that's an easy target right now to go and bring litigation, because you probably have courts saying, we think it's probably better this way. And if that's the case, now that Chevron is gone, if you're allowed to bring it back up now under Corner Post, you're just going to have more and more of these cases. It's going to be on skates for a long time.
And then the forward-looking perspective here is that, yes, it's a power grab from the court's perspective, but it is also trying to shift power from regulatory agencies, let's say, back to Congress to a certain extent. And it's under this expectation, hope, or maybe they know what they're doing, in that Congress now needs to be, as we were talking about earlier, need to be resourced effectively in order to make much more specific laws that are also better stand the test of time, because things change rapidly, and that seems like a completely absurd and impossible task for Congress to take on. And then I saw this quote from a libertarian about this: the end of Chevron deference will make it slightly harder for special interests to dominate agency decision making. But when you look at it from a congressional, and I'm not even going to say I agree or disagree with that at all, but if you look at it from a congressional perspective, the idea that special interests can play a lesser role in the laws that Congress is writing is just absolutely absurd. And so I think it's a bit disturbing at what this can mean from a forward-looking perspective in terms of regulation and regulatory agencies trying to stay on top of an ever-evolving and changing world.
We like to think about this stuff having some implication for business and the business community. One thing that probably doesn't get highlighted enough is that the business community really benefits from clarity and stability. If you're going to put capital out and build up a compliance program or arrange your affairs in a particular way, understanding what the rules of the game are, if you are continually changing the rules of the game, with each different circuit court decision, it's just going to create a lot more uncertainty in the business environment, and that's not good for business. So there's, I think, a lot to be concerned with here.
There are also, to build on Ben's point, a lot of large incumbents in regulated industries have kind of competitive moats that they've built up around, some of the things like, experience handling the compliance in this area, right? And that's sometimes makes it hard for, raises barriers to entry, right? Reduces competition. And so one implication here might be that, it might be not just to create more uncertainty on a forward-looking basis for existing companies, but to open up incumbents to, who have arranged their business affairs around a particular idea of how some sector of the economy is going to be regulated, all of a sudden face, a new challenge or, some new kind of congressional intervention that upsets everything, or at least upsets the settled expectations. And so that I expect to see that in a lot of areas. I don't know how much we're going to see it in SEC land, but that chapter remains to be written.
One thing that I saw is this idea that Chevron doesn't really apply to the most significant agency decisions. So those that involve questions of major economic and political significance, that involves the major questions doctrine. Is that how accurate is
Yeah.
that?
Well,
is that perspective?
okay. So Professor Tierney, I think, nailed this with a lot of these decisions do appear to be maximizing the court's power. And the newly recognized major questions doctrine is one of these, where essentially, if it is a truly major question, the court says essentially that's reserved for Congress. Now, who decides whether or not it's a major question, and what makes it a major question? Well, it really depends on whether Justice Gorsuch has had Frosted Flakes or eggs and waffles for breakfast. We don't have any real great guidance on what is a major question. So if an agency is doing something it hasn't done before, even if it has long had a power, or seems to have long had a power, and there's a hue and cry about it doing something different than it's done in the past, it's a good chance it'll be treated as a major question. But if you ask me to define the clear boundaries of where that doctrine begins and where it ends, I don't know. And part of that is just the reality of, if you're going to say, what exactly is a civil penalty, in the Jarkesy decision, or, after that, or what is a major question? That's, in some sense, that's what a lot of law is about, is a hot dog a sandwich? And that's sort of where we are. With a lot of these, where you're trying to figure out do we put this in this category, to put that in that category? Where's the strike zone here? And, again, the composition of these courts really matters for deciding those kinds of questions.
And I would just add on Ben's point that it's not just that this is slippery doctrine. It's made up. It's made up by charlatans who are pulling from nothing in the text of the Constitution, nothing in original practice. All of the scholarship on this, well, I shouldn't say all, but the compelling scholarship on this point suggests that, delegations to agencies were common at the founding, and it wasn't really a problem that you would have, let agencies kind of handle how to work out administration. And so it's just this completely made up idea, and we're stuck with it, that now whenever the court decides that something is major enough, they don't have to do any kind of special deference, whatever that might be, to what the agency thinks. So I am pessimistic for the future of administrative policymaking. I am teaching administrative law this next spring, and I think I might just throw out the casebook. Right? I'm not sure what I'm going to teach.
Jeez. All right. So let me ask you then, and maybe this is I don't know if this is a perfectly relevant question, but it's not quite sort of in the financial regulation sphere, but it's something that I've been sort of passionately following and really excited about over the last couple of years. I think the most impressive accomplishment of this administration has been in antitrust. And there you have an administrative agency that has decided that it is not going to do what that agency has done for the last, let's say, 3 or 4 decades since, Reagan, and it's actually going to enforce antitrust rules and law, or antitrust laws, in a way that really we haven't seen in a long time. Do you think that these decisions strike at the heart of that? And is this something that we're going to, along with financial regulation, is this an area that we're going to start to see some really disturbing things happen?
Yeah, absolutely. So if you think about the FTC, their courage had been sitting dusty on a shelf, and they finally decided to go get it back and do something about it. Well, now it's a major question whether or not you can open that closet and have some courage and try these hard cases. We may ultimately end up with a lot more clarity in future cases around what the boundaries of this is right now. But where it stands right now, it's just very difficult as a practical matter to advise a client and predict where the boundary line is going to be.
Yep. All right. So we're not leaving this on a terribly optimistic note. I'm afraid, James, I share your pessimism. I think that if you look toward the future, certainly the immediate future, we could once again be facing an administration that wants to dismantle, federal agencies, strip them of knowledge and experience and expertise in favor of ideology, which I would, on both sides, I would say is a serious problem. So it really seems concerning, how long before we're all drinking Brawndo and using it to water the fields. I don't, I'm
it
scared,
is what plants
but
need,
we'll see.
Right?
It's what plants need. Yeah, that's right. So thank you both for joining us. I think you've really helped to make these sort of esoteric and difficult questions of constitutional law accessible and entertaining. And I think that's a pretty rare feat. So we really appreciate it. And I'll leave on this note, as Pink always says, register to vote. This is a pretty consequential election, and the courts are making it more consequential by the day. And so, that's the best way to express yourself. So thanks again for joining us on Let's Talk Markets. We'll look forward to having you guys on again when the next major decision that destroys the administrative state comes down from the Supreme Court. And until then, we've got some pretty cool episodes, I think, coming up over the next couple of weeks. Yeah. And,
we'll see you soon.
Yeah. All right. Oh God. Okay. Sorry. Sorry to hear that. All right. Thanks, guys, and thanks everyone for listening. Make sure to like and subscribe, and leave your questions down in the comments, and we will certainly try to get to them in the next episode.
Thanks.
Thanks.